Welcome back to Supreme Myths. My guest today is Professor Jamal Greene, who is the Dwight Professor of Law at Columbia Law School. He clerked for Guido Calabresi on the Second Circuit and for Justice Stevens on the Supreme Court. He graduated from Harvard College and Yale Law School. He's written more articles than you can imagine, including one called The Selling of Originalism, which has had a huge influence on my work. And his new book, and if you're watching this on YouTube, I'll hold it up if I can somehow. His new book is How Rights Went Wrong, Why Our Obsession with Rights is Tearing Us Apart. Jamal, welcome to Supreme Myths.
Thank you, Eric. Good to be here.
So I have reviewed your book for constitutional commentary. It should be coming out, I don't know, who knows when, but sometime soon. I love this book, even if we disagree some about the solutions. It is such a wonderful book. So why don't we start with, why is our obsession with rights tearing America apart?
Sure. So I think the main thrust of the book is trying to reconcile the presence of rights and the importance of rights, which I very much believe in, with the fact of pluralism, the fact that we are all very different from each other, have different values and commitments. And I think sometimes we tend to think about rights as if, we can all sort of protect our rights all the time and they're not going to conflict with each other. And if they're just rightly understood, then you eliminate conflict. But rights are inherently support and are consistent with conflict. And so I think the job of those of us who adjudicate rights conflicts or try to resolve them is to try to manage the conflict. And I think too often we, instead of doing that, we try to essentialize the rights and sort of figure out who has rights and who doesn't. And that tends to be polarizing. It tends to distort rights in all kinds of ways because we essentialize them, and then we have to kind of pull back on that when we recognize that they can't be pushed as far as we'd like. And so I'm trying to call for ways of kind of mediating among rights and reconciling them, and thinking of some strategies for doing that instead of kind of essentializing them or thinking of them as almost absolute.
One of the many questions, important questions, I think your book raises upon reading it is how much of America is being torn apart by the Supreme Court's determination of rights, or how much the Supreme Court's determination of rights is polarized by our other factors outside the court's control. Is it kind of a chicken and egg thing? I'm not sure where you totally come down on that question.
Yeah, it is a chicken and egg problem I don't deny that. I think one thing to be clear about is that, look, we are divided and polarized in all kinds of ways. And there's nothing about, notwithstanding whatever the publisher might say, there's nothing about reading this book that's going to, undivide us or unpolarize us. The problems are way deeper than how, courts think about rights, or even how the rest of us think about rights. It's a very complex set of problems. I do think that courts aren't helping, and I do think that there are any number of ways in which we can observe the way that courts model the thinking about rights and the way they actually resolve particular controversies that tend to push us into our corners rather than bring us together. And judges are an important part of civil society. They're an important part of government, of course, and they can act as models, and they can they actually have a bit more institutional respect built up than a lot of other institutions. So I think there's a lot of money on the table that's being left by the way we think about rights. It's not going to solve everything, and it's not the source of all our problems. And certainly courts are influenced by the way we think about rights too. So it's a dynamic kind of process. But there are ways we can do better, and that's what the book is really focused on.
So one of the most fascinating and interesting parts of your book, and by that I want to say this book is accessible to the most elite law professors there are, lawyers, informed non-lawyers, really everybody can read this book and really get something out of it. And one of the most fascinating parts of this book to me is how you talk about judicial review, how courts act in other countries. And Justice Roberts, I think, did you a big favor in the in the Dobbs argument last week, and we'll get to that, by talking about other countries and abortion, and we'll get to that. But before we do, other countries do it quite differently than we do. I don't mean in terms of term limits and structure. We can talk about that. But how they deal with rights is different in Germany and other countries. And I think you say a lot of interesting things about that. What do you want the listeners to understand about how we do it compared to how they do it?
Well, there's an approach, and there's a way of talking about this that really gets into the weeds and gets really very legalistic. And there's a way of talking about this that's a little bit more accessible. And I do appreciate that you're noting that the book is designed for everyone,
Yes.
not just for lawyers.
Yes.
So the more accessible version of the argument is that when we see a rights conflict, right, there's a couple of different ways we can think about that conflict, right? So let's say it's a conflict between someone who doesn't want to get vaccinated and someone who thinks that I'm sitting in New York City where a vaccine mandate for private businesses has been announced.
Right.
We can think of that dispute as we have to figure out if you have a right to not be vaccinated, right? And if you have a right to not be vaccinated, then the government probably can't vaccinate you unless it's some kind of emergency, or require you to be vaccinated unless there's some kind of emergency. And if you don't have a right to be vaccinated, then the government can do whatever it wants. They can, make you be vaccinated against anything. And for any number of reasons, our law, American law, has sort of tended in that direction. It's like the job of the decision maker is to figure out, do you have that right? And we're going to figure that out by looking at the text, or maybe there's some authoritative precedent in the past that tells us the answer to that question, or maybe the founders can tell us. We can use originalism in some way, depending on what your jurisprudential stripes are. But the other way of thinking about that question, and the way if you took it out of the sort of domain of courts and law, is to not think about sort of legal abstractions like, is there a right to something? You think about, well, why is the government doing this? How burdensome is it to impose a vaccine mandate on someone? What are the arguments that someone's making about the costs associated with them? Is there something the government could do to respond to the problem that doesn't require this interference with how people understand their particular interests and entitlements? We're all going to answer those questions a little bit differently because we're all different from each other, and we're going to argue about the answers to those questions.
Yeah.
But those are the right questions to ask if we're talking about the justice of a vaccine mandate. Like what James Madison thought about vaccine mandates is not the question one asks. If one is trying to figure out, is this a just government policy or not? The kinds of the questions that I think rights really are about justice, right? So I think we should not abstract ourselves away from that fundamental truth. And so there are a bunch of questions you can ask that go right at questions of benefits and burdens and reasons and motivations. And other countries tend to develop their law around those kinds of questions, as opposed to the question of, do you have a right? Do you have a right just doesn't get you very far in answering the kinds of questions that most of us disagree about. We all agree that you have certain basic rights and that those rights have limits. So let's talk about those limits rather than talking about whether you have a right or not. That's just not a very interesting question usually.
So one phrase you use throughout the book, proportional judicial review, is I think how other countries kind of view that. Can you kind of explain that I know you could take 3 hours to explain that, but could you explain that in a quick kind of way?
Yeah, so proportionality is and I don't want to overly praise the Canadian or the German approach. They have their issues as well,
sure,
right? But the general theory of proportionality approaches rights through a kind of structured balancing. So where you ask a series of questions: is there a right? And that's usually an easy question. Proportionality jurisdictions tend to have an expanded understanding of the various things that count as rights.
Right.
And the reason they have an expanded definition is because that doesn't really answer the interesting questions, right? So the interesting questions then are, well, what's the government trying to accomplish? Is that something they legitimately are able to try to accomplish? So in my vaccine example, public health, okay, that's a legitimate objective. Is there a basic means ends fit relationship, proportionality in a sense, between the means and ends? Is this vaccine requirement directed at public health would be the way you'd answer the question in my hypothetical. And that's usually a pretty easy thing to pass for the government to pass too. In most jurisdictions that use proportionality, there's two other questions that are harder for the government typically. So the first is is this the least restrictive alternative? And we recognize this in American law as something like a component of an intermediate or strict scrutiny
Right.
test. Are there other things the government could do that would accomplish its objectives without interfering with rights? And that question is asked across a very wide range of problems and disputes. So in that sense, it's actually more favorable to rights in that sense than typical American law is. And then there's a kind of a final test, which is a kind of in other countries, and this is basically every other country, every other advanced democracy uses proportionality analysis in some form or another. So the U.S. is really the exception here. But the last question is what's often called balancing in the strict sense, which is to say, how much is this government policy contributing to solving the problem the government's trying to solve in relation to how costly it is to the person who it's, you shouldn't use a nuclear bomb to squish an ant, right? Even if it's the least restrictive
And I hate
means.
ants too. I hate them. But yeah.
Even if the only way you can kill the ant is to destroy everyone else, and even if it's totally legitimate that you get to destroy that ant, if you're using a nuke, then you can't do it, right? So, so there's a final balancing that is typically considered to be part of the proportionality test. So it's a balancing of a sort, but it's a kind of balancing that happens across a very wide range of disputes. So it's actually more judicial involvement in a sense, but judicial involvement is never quite gets to the point of once you declare a right, that means the government's got to win, right? We really have to ask questions about what the government's purposes are. Is it basically being reasonable? It usually has some deference to legislatures baked in, right? Because a lot of these kinds of questions are basically empirical questions or questions that rely on data or reasonable inferences or judgments that you can make about data. And you don't want courts and legislatures to be to be substituting for each other there.
Right.
But it's you might think of it, for you lawyers out there, a kind of broad-based intermediate scrutiny of a sort.
Right. So an observation and then a question. I hope this observation makes you happy. I will find out. Reading through your book, it really did. Many parts of the book reminded me of Justice Stevens, who I, by the way, think is one of my favorite justices and who you clerked for.
Thank you.
That's a compliment. Good. One of the things I think that was so wonderful about Justice Stevens was his ability to get past legal formalisms, like the kind you were talking about, and get to the heart of the matter. Some of my favorite dissents in constitutional law are from Justice Stevens. For you lawyers out there, and the Pennhurst case, I think his dissent is brilliant, and there are many others like that. And so my question is, I guess, how much did he influence you? And then the second part of that question is whether your knowledge of him or you personally, are courts supposed to, if we're going to do the kind of balancing you suggest in this book, are courts supposed to take into account their perceptions of public reaction, their perceptions of what the public will tolerate or wants or doesn't want, which legislature should do, right? But I'm not sure courts should do. So I guess those are two different questions. But I think Justice Stevens wrote in a way that was incredibly anti-formalistic without doing the second thing. And I'm just wondering what you're thinking.
So good. I don't know that I know the answer to either of those questions, but I'll give a stab at it. So on influence, I'm sure I was influenced by Justice Stevens in part. I wrote an early piece. In fact, that I've written many pieces about Justice Stevens over the years, which is what happens when you clerk for someone and then you're an academic. But I think the second of those pieces was a piece right at his retirement. Called The Rule of Law as a Law of Standards.
Yeah.
And it was essentially the title is a play on a well-known article by Justice Scalia called The Rule of Law as a Law of Rules, in which Justice Scalia defends his very rule-oriented approach. And I was trying to say that you can have an approach to law that is based on non-formalism, on kind of developing standards over time. And that doesn't mean that you're not acting within the rule of law, right? It doesn't mean that you're lawless. That there are ways of thinking about standards rather than rules in a structured way. And proportionality is trying to do that. And Justice Stevens himself never endorsed proportionality. Justice Breyer has done it on many occasions, but Justice Stevens never did. But I recognize in a lot of his jurisprudence a consistency with that kind of analysis. I think of, and maybe you're thinking of as well, his concurring opinion in Craig versus Boring,
Yes.
which is the case announcing intermediate scrutiny for sex discrimination, where he says, I think that sex discrimination is usually a problem, but it's not that we should apply these very specific tests based on what kind of discrimination's at issue. We have just there's just one equal protection clause, and it just applies to say government don't do unreasonable things. And I'm very sympathetic with that approach, and I'm sure I was influenced by it. The reason why I hesitate a little bit is because of something that the other judge I clerked for, Guido Calabresi, told me recently after reading the book. And he said, this book comes out of a case that we had when you were a law clerk. And and Guido is a brilliant guy, and he noticed something that I had not noticed, which is, I think he's right about this, that there was a case we had, and this was on the Second Circuit, where it was a bunch of a couple of police officers and firefighters who had participated off duty in a Labor Day parade in which they acted out some racist tropes and stereotypes, and they were punished by the mayor basically for they were eventually fired, and they brought a First Amendment challenge,
right,
saying we're allowed to engage in speech on a matter of public concern. We're really talking about race and so forth. And that raises the question of, when you think about freedom of speech, do you just say they're exercising their free speech and therefore, the highest possible standard applies to government interference with that right? Or do you kind of start with the question of, well, these are police officers and firefighters who have a particular role in the community. And so we always have to kind of temper how we think about free speech based on on someone's role within society. And so thinking about the difficulty of wrestling with those questions, I think really did start with that case way back when.
Yeah. Go ahead.
But on your second question on public opinion, I have mixed feelings about this, and I think if you were to read all of my work, you would see the mixed feelings coming through, because I think I say some things over the course of my work that are not always consistent with each other, right? So I do think that judges, when you're talking about public law, you're not just talking about a contract dispute between Jack and Jane over Blackacre, right? You're talking about when judges decide constitutional cases, they're making the law for the country. As you've said many times, like the Supreme Court's not a court, and
thank you.
It's
for
not, and that's right. It's not a court in the same sense in which you and I might go to a court over a contract dispute, right? It's a court in the Kelsenian sense of a constitutional court when it decides public law cases.
Right.
So it is making law, notwithstanding whatever you might hear at a confirmation hearing. It's indisputably making law because it makes prospective rules for governing society more generally. And so insofar as it does, you've got to pay some attention to public reaction to the rules that you create, because you're governing a society, a democratic society. And we're not a country that amends our constitution very often. And so it gets built out over time by court decisions, by decisions of others as well. Paying no attention whatsoever to public opinion seems to me to be wrong. That you've got to pay some attention to the society that you're governing. But at the same time, that can't mean you're putting your finger to the wind and being influenced by whatever the polls say. You've got to find, there's some middle ground between I'm just I'm a politician who listens to my constituents, and I am a judge who develops principles, but doesn't do them purely abstractly, but does them in a way that is attentive to the society that they come from. And I think there is a way of navigating that, but it's hard.
So it's interesting. You and I are frequent visitors to the San Diego Originalism Conference run by the San Diego Law School, and Mike Rappaport and Mike Ramsey, other people. I think if we suggested at that conference that public opinion has a role, maybe small, medium, whatever, they would lose their lunch, and yell at us and scream at us for a very long time and say, no, constitutional interpretation is supposed to be about text, history, precedent. And the more sophisticated one, or the more honest ones, would say also there's a space for consequences, maybe, but it's emphatically not the duty, quoting Murray versus Madison, emphatically not the duty of the court to say what public opinion is. And I've always thought that's really naive, because they come from, these aren't strangers who came here from another land looking at us objectively. They are part of the public, and they've been raised in a certain public milieu that makes that almost inevitable. Do you think I'm wrong? Is that fair?
I think it is inevitable for the Constitution that we have.
Yeah.
I think if we had you could imagine a different Constitution to keep with the quotes of John Marshall. If we had a legal code.
Right.
Right. And it was just, we're going to list all of the powers of the government, and we list all the rights of the government. And if it doesn't fit squarely within the very specific things we've listed, we're going to list 1,000 rights that you have, right? We're going to list and we're going to, at the level of specificity at which courts think about rights, right? So we're going to tell you if you have a right as a police officer to participate in a racist parade, like that's going to be listed there in the document. If you got that specific, then maybe I'd agree that there's no space ever to sort of look outside of the document, right? And so if you need to amend that, you just go and amend it and decide what we the public think about this new scenario that but that's not how our Constitution works. That's not how most constitutions work. And instead, we've got things like equal protection and due process of law and abridging the freedom of speech. And those are not, and that cover those three provisions cover almost all of the rights conflicts that we actually have, and those don't lend themselves to some kind of fixed interpretation.
Right.
They announce principles that are supposed to guide the government, and so insofar as they announce a set of principles, I don't think it's in the nature of principles to be frozen in time. I think it's in the nature of principles that as we learn as a society, as we evolve as a society, as we debate as a society, those principles evolve too. And I think it's fair to say, this is consistent with Jack Balkin, let's say, a certain kind of originalist on his account.
Okay.
That the Constitution tells us to take into consideration public opinion. Now, public opinion again it'd be derisive to say that it's a Gallup poll or something like that, right? There are other ways through which we acknowledge how the people of this country think about these principles. We look at legislation, we look at prosecutions, or we look at writings from influential people. We look at art. We look at lots of things to figure out what our constitutional culture is, and I think judges have an obligation to pay some attention to that.
So, as regular listeners of this podcast know, I'm obligated to mention retired Judge Posner at least once a podcast. So I'm going to do that now. Two things Posner said that I'm wondering how you would react to. I think one is pretty simple. Constitutional law, he said, is not about logic and text and law, really. It's about taste and values. And the way he put that was, when somebody says, I like a margarita better than a cosmopolitan, I'm sorry, strike that. When somebody says a margarita is better than a cosmopolitan, what they're really saying is, I like margaritas better than cosmopolitan. In my classes, I always say, is Godfather 1 better than Godfather 2? Answer, yes. But what I really mean is, I like Godfather 1 more than Godfather 2. And he says that's true about abortion and capital punishment and a million other constitutional law issues. So I'm curious your reaction to that. And then the second part of it, which is related, is he thinks it's really all about creation at the Supreme Court level. He absolutely recognized precedent, vertical precedent, and he hated Heller, but he struck down an Illinois gun law. He respected precedent. But at the Supreme Court level, he said it's just creation, and calling it interpretation is wrong. It's not what they're doing. And I'm curious what your reactions are to both of those points.
So first, I agree that Godfather 1 is better than Godfather 2.
Yay! Good.
We can fight that fight together. So I don't know that I'm with Judge Posner in saying that interpretation is not quite the right language to think about how to resolve conflicts.
Mm-hmm.
That interpretation is a legal abstraction, right? It presupposes that there is a text, and that the text, properly interpreted, tells us how to answer questions. And I think that that's emphatically untrue for a very wide range of things that we disagree about when it comes to U.S. constitutional law. Not everything, right? I think there are some things that the text pretty well establishes, but most of what we disagree about, especially in the rights space, the text doesn't get us very far. And so we're doing something else when we resolve those disputes. Whether to call it creation or to say that it's purely based in values, I suppose if you said that one of those values is adherence to a certain style of argument, I might agree, right? So, and here's where Richard Posner and I differ is, and maybe he would get to the same place through a different avenue, right? But I think that the practice of constitutional law is by and large the practice of arguing about problems in a certain way. And so as opposed to arguing about abortion rights by saying my God is better than yours, or by saying, I believe in fetal rights and you don't, arguing about it through a set of materials, some of which is text and history, but those don't get us very far with this particular kind of issue. A lot of it is precedent, right? So the thing that makes judges interesting and different from politicians is right that they decide a case and then the case is decided. And so unless you have some very extraordinary reason, you don't go back and revisit the old cases. And you navigate the law as it is, and the law as it is includes the prior decisions. And the way you talk about it is to say, is this consistent with Casey, et cetera? Now, I think there are some ways in which that ends up being reductivist and problematic, right? So I do think that the way in which we should develop the case law is by reference to certain kinds of consequences and certain kinds of burdens and costs and so forth. But I don't not believe in precedent, right? I do think that courts should pay attention to what they've said in the past. It's just I have a different view about how they should, what kinds of factors should be relevant in developing the law in particular directions. But there is a difference, right, between the way that courts should talk about these things and the way that politicians should talk about these things. And I don't know that, Posner might say yes there is, but only because otherwise people wouldn't listen to courts. And so so there are kind of instrumental reasons why courts should do that.
Jamal, he would say that exactly. He said it to me many times. Yeah.
Right. So I don't know if I'm quite there. Right. But the fundamental insight that it's a fiction, and I think a destructive fiction, that we resolve sort of difficult rights conflicts through something that you could reasonably call interpretation. I think that's right.
Do you think? So I'm on record on this, and you won't be surprised where I stand on it. Do you think the Supreme Court cares about precedent in cases they care about? Obviously, in cases they don't care about, sure, it's a management issue. But in cases that they emotionally, care about, do you really think they care about their own precedent?
I do, and I think the Supreme Court is, it's a they rather than an it. So like,
sure.
Different. I might say this differently about different members of the court.
Mm-hmm.
But there are members of the court who I think quite transparently care about precedent. I mean, John Roberts, I think very clearly cares about precedent. And there are he's often criticized for, you're really just trying to, when you say, and you think about his highest profile cases, Shelby County, where he moves the law in very significant ways, but does it only after trying to kind of slow down in the Mudno case that preceded it, to say like, look, we're going to make a big change. You got to do it slowly. We've got to build up our precedents. Same thing with Citizens United, where he didn't write the majority opinion,
Right.
uh, but there was an earlier case, Wisconsin right to life, an earlier case where they could have overruled, and he tries to go narrow because he doesn't want to move the law too quickly. There's June Medical, obviously, where of course he does say some things that suggest that the law is going to change. He wants the law to change in a particular, more conservative direction, but he votes
But Jamal, on
to
all those cases, I'm sorry to interrupt. On all those cases,
yeah,
and those are big cases, right? That's the Voting Rights Act, that's
yeah,
abortion, that's
big
campaign
cases.
finance reform. I'm just going to self-promote here. I have an article out in Washington and Lee just recently saying that what you just said, he cares about precedent some and moves slowly and incrementally, and of course that's the conventional wisdom. I don't agree with that. I think it's all hubris, and I give my evidence in that article. But what I want to ask you is, do you think it's about precedent, or do you think he cares about perceptions of the court? Those aren't the same things, or maybe they are the same thing. I don't know.
Well, I think they serve the same ends.
Okay.
I don't think it's the case, and this is a very important point, right? I think the Constitution can be interpreted in ways that lead in conventionally conservative directions, and also in ways that lead in conventionally progressive directions, and have both of those interpretations be faithful interpretations of the Constitution, right? It's sort of baked into my views about constitutional law
Right.
that has to be true. And so, insofar as that's true, we pick judges through a political process. We pick judges through a political process because, for reasons we've talked about earlier, right? Because we actually want them to reflect the society in some way, and that's a feature, not a bug, right, of our system, that they're not totally external from society. And I don't think one can ask of them that they not move the law in the direction for which they were selected to move the law. I think we can reasonably ask of them that they do it slowly, that they do it with some attention to the norms of judicial practice.
See, I don't think Roberts does that, but we'll move on from that. Go ahead.
Yeah, I mean, we can argue about whether he does it or not, right? But I think that's something to be commended, even if it's moving in a reliably or identifiably conservative direction. And I'd say the same thing about progressive judges, right?
Sure.
I'm a progressive. I want to see progressive outcomes. I don't think it's bad for progressive judges to seek out progressive outcomes.
Right.
I do think they should do it slowly in general.
What should lay people make of the following argument that I often make, which is that let's just take Alito and Ginsburg and Souter. Of course, Ruth Bader Ginsburg, I think, is an American hero. As a litigator, she changed America. She changed gender rights. She deserves all the honors and awards she could get, for that contribution to our country and to equality. As a Supreme Court justice, she voted progressive or liberal 98% of the time in big cases. Justice Alito, I don't think, has he ever voted liberal? I don't know, maybe, but I mean, obviously he votes conservative. Even Scalia voted much more liberal than Alito has done in his career. And then we talk about a Souter or a White or a Stevens, even in the earlier part of his career, certainly, who are more moderate, and therefore their results are mixed. Justice Stevens was in the dissent in Texas versus Johnson. That's the flag burning case. I think a lot of people were surprised that he dissented in that case. So we have an incredibly liberal person, voting liberal almost all the time. We have incredibly conservative Justice Alito voting conservative almost all the time. And then we have Souter, White, Blackmun, Stevens, who went back and forth. And it's my thesis that's because of their values they brought to the court, which are extraneous to text and history of the Constitution. What should lay people make of that, if I'm right, if you agree with my account?
I think that your account is basically right. And I think I agree with it. I'd have to think more about the specifics, but I think I agree with it. And I think that's a system, generally speaking, that's a system that can work. Now, I don't think one can say in the abstract that someone who votes the conservative position every time and someone who votes the progressive position every time is necessarily acting within bounds in all those cases. I don't think I think one has to look at the specific cases.
Fair enough.
Because I do think, again, I do think there are norms of judicial behavior. I think they're intelligible. I think we can argue about them and identify people as flouting them or not flouting them. And the same is true of the people in the middle, by the way.
Sure.
I mean, being in the middle just for the sake of being in the middle, which I think some people sometimes accuse Justice O'Connor of doing,
Yes.
is I think not always great. But the very fact that there is a range of values among justices, and they bring those values to the project of resolving big public law disputes, I think is a triumph for democracy. I think it stops being a triumph at the point at which they're not doing something that's identifiably different from what politicians do. And I don't know that I would say we've historically been at that point. Partly because and this goes back to what I said in defense of John Roberts, or in qualified defense of John Roberts, which is that time is really important in politics. If it takes 20 years to get from point A to point Z, that's really very different from it taking 20 days to get from point A to point Z. There are a lot of points of intervention, a lot of veto points, a lot of room for argumentation and redirection over a 20-year period. And I think that's really constituent. That's what the court brings, right? It's not that it brings some, a distinctively legal perspective to, these fraught political debates. It's that it gives us time to decide them. And it gives us time to decide them because it observes certain norms of gradualism and certain norms of framing their debates in somewhat orthogonal terms. So I think there are better ways of them giving us time, by the way. Like, I think that the way they think about remedies, I think there should be more explicit dialogue between courts and legislatures. But part of my reason for thinking that is that the benefit that courts have, the benefit of judicial review, is that it slows down evulsive political change. And that's really valuable in a pluralistic society.
So one more kind of general question about your work in your book, and then I want to do a lightning round of current events, if you don't mind, because you're a thoughtful observer of current events, and I didn't mention it, but you published op-eds in all the major newspapers and stuff. So I do want to get to that. But other courts have specialized constitutional courts, where I assume the judges are picked for a set of skills other than simply lawyering skills. Justice Roberts was a great lawyer. I think we can all, at least all accounts of him, or that he was just an excellent lawyer. And there have been other examples of that. Other countries have very different confirmation processes, and I think they look for other values in their specialized constitutional courts. Would you, we might have to amend the Constitution or not, I don't know, but I'm not sure we would. But leaving that aside, would you be in favor of kind of separating the court's functions, statutory interpretation, arguably maybe diversity over there, constitutional law over here? Having different people do different things.
Well, I would say that I would want to revise our confirmation process if we did that.
Yeah.
I will say, here's a plug for my testimony to the Supreme Court Commission.
Yes.
Which suggested a number of ways of changing how we think about our court. What I would like about that proposal is that it would force the court to be more self-conscious about its role as a different kind of institution than an ordinary court, right? So that when we think about things like standing, when we think about things like political question doctrine, when we think about things like advisory opinions, right? There are a range of reasonable views about all of those things, but we should be thinking about those kinds of questions in understanding that they're being answered by a quasi-political institution, right? Not one that is just the same as like the common claims court where you resolve your dispute over your toaster or something.
Right.
Right. I mean that Marbury versus Madison, right, has a very specific conception of what judges are about, and that's a conception that's born out of assuming that most of what judges do is like resolve disputes between debtors and creditors.
Yes.
As opposed to decide what the law is. For everyone, and second guess the legislature and second guess the president. And when we're in that situation, it's an adjunct to other kinds of democratic processes, and we should structure it in a way that makes that clear, where we're not fooling ourselves about what kind of institution we're talking about. So I find that attractive.
Yeah.
I don't know if I would just convert the court as it is with all of its current structures and personnel into that kind of court, but I do think that's an attractive self-conception.
At the heart of the criticism of my work and my thesis that the court is not a court, people respond, what you're really saying is it's a bad court, or what you're really saying is it's a different kind of court. And if I really want to be reflective on this, I think what I am saying is we can call it a court if you want, but as you've been really articulate in saying today, it's a very different kind of court and a different mission than Fulton County Superior Court or the trial, or even the New York Supreme Court or appellate courts or whatever. Right. That's pretty clear, right? I mean, that's...
Yeah, absolutely.
Yeah.
And other countries that have separate constitutional courts explicitly recognize that.
Right.
And they structure the procedures of that and the remedies of that court on that assumption.
Right. Okay. So thank you. That's awesome stuff. Let me just go through a quick litany of current events. So last week, of course, was the big abortion argument in the Dobbs case, and Roberts did two things. I know one of which you probably liked is he referred to other countries and what they do, and maybe we should take that into account as a general matter. We already talked about that. I could not believe that 3 times he referred to the private papers of Justice Blackmun to suggest that Blackmun thought that the viability line was arbitrary, even though it turns out, as I think Linda Greenhouse wrote last week and others have written, that was a very preliminary memo that he signed on to Roe, of course. He wrote Roe. He signed on to Casey. He signed on to the viability line. What do you think about why would Roberts do that? It seems, I don't know if I've ever remembered a Supreme Court justice during oral argument referring to the private papers of one of the people on the court.
Yeah, I mean, I guess I'm not too bothered by it at oral argument. I mean, right. So one of the things I would do with I think oral argument's too short. I would have oral argument be like 4 days long, right, rather than a few minutes, so that we could and so from that perspective, I think I like open conversation, right? And if the argument is over whether viability is an arbitrary line or not, I don't think it is an arbitrary line. But if one's arguing about that, and one of the things in your arsenal is, the guy who invented it thought it was an arbitrary line, I wouldn't say you're sort of not allowed to refer to that. That said, I wouldn't, to your first point about him referring to foreign law. I do think we should pay attention to what others do when they're faced with similar problems, right? And it's not like only the U.S. has struggled with how to think about abortion rights, but the kind of selective, if you're not someone who really has deep knowledge about what's happening in a foreign jurisdiction, if you're in fact in most instances not committed to not taking it into consideration, I think you're then kind of stopped from saying, oh, well, but we're going to pull this sort of one thing out of, if you say like, yeah, we look at foreign law and bring on the briefs, like, so we can actually dig into this. That's one thing. But if you say, don't, as you said at his confirmation hearing, we don't pay attention to foreign law. Oh, but now that I see this one fact that I find helpful, without any context of the surrounding facts that are also relevant to this question, that I would object to.
Okay. What do you think of Justice Barrett's, I think 3, I could be wrong about that, but I think 3 questions or statements that the greater availability of adoption today undermines some of the rationales of Roe and Casey? And I ask that knowing that you think that's the kind of question that might be relevant, and it's not a textual question, it's not a historical question, it's kind of a part of the many, many factors smart people have to think about when going through different perspectives on abortion. But I'm just curious what you thought of that line of questioning.
So I was surprised by it.
Yeah.
I will say that.
We all were.
And I was surprised by. So let me just say that I think that if one were to write an opinion that said that the reason why abortion rights can be limited is because people can just give up their kids for adoption after they're born, if that's what you were to rest on, I would say that that's I would be highly critical of,
Yes. Yes.
to say the least,
Yes.
of that reasoning. I think it's insufficiently, horrifically insensitive
Yeah.
to the burdens of unwanted pregnancies, to the burdens of pregnancy in general, the burdens of childbirth, to the burdens of actually giving birth to a human being, and then what that means emotionally for someone. I will not assume, and I would have wanted her to give a little more context to that
Yes.
kind of question,
Yes.
given the reasonable inferences one can draw about why she was asking it.
Right.
That said, I'll wait for the opinion
Fair enough. Fair enough. Yeah.
before I pile on that. Given that it's part of the job of a person or oral argument to probe the limits of an argument, and I'll just chalk it up to maybe not seeing how it would be perceived, unless and until I see an opinion that shows the deficiencies that I think we're all rightly worried about.
I was going to move on, but the last point you made is really interesting. One of my pet peeves of the last 5 years is that I know Amy Coney Barrett a little bit, and I've always had very positive interactions with her, and by all accounts, I think most people would say she's a very nice, decent person in person anyway. When she was nominated to the Seventh Circuit, I made the point, I may even have included you in this, I don't know, but I think I did. I made the point that there are so many law professors. She was a law professor at Notre Dame, for people who don't know. She was relatively very young, to become a judge, and she had very little practical experience. And I made the point that there were hundreds of law professors with resumes longer than hers. When better, I mean just more books, more articles, more. And she was somewhat inexperienced to go from that job to the Seventh Circuit, knowing that she was going to be in the Supreme Court if someone left, which of course happened to Justice Ginsburg. And that whole idea of putting this relatively inexperienced lawyer, very experienced law professor, but then a judge for only a couple years before they get to the Supreme Court, it just really disturbed me. I think we can look at Ginsburg or even Roberts and say, look, Roberts was known as one of the great lawyers in America. He was known for that. Even Scalia, who I can't stand, he had an intellectual reputation not deserved, but he had it before he got to the court. She doesn't have any of that, other than she's a really nice, thoughtful person. Well, there are a lot of really nice, thoughtful people out there. And I think she did, and the reason I'm saying this to you is you triggered me by saying she might not have expected the reaction she got to what she might have thought was kind of an innocent line of questioning. And that's important, I think, especially now that it's being live streamed on the audio. I don't know. I guess I'm asking you to react to all of that. I don't know what you can say.
Yeah, I mean, I think that's fair. I think everything you say is fair. I mean,
Okay.
and I've only interacted with her some,
Yeah.
as a law professor, not much at all.
Uh-huh.
And my impressions are the same
Yeah.
as yours are. And it's for sure the case that there are more experienced people who could have been nominated. I wouldn't take that too far, insofar as that's always sort of the case. But you're right. She was picked. It seems to me that she was picked mostly because she's young and smart and was believed to be a reliable vote on this specific issue.
Yeah.
Abortion rights, and is conservative, right? So I actually tend to think, my reaction to that is that that's actually a little bit risky for the people on the right, right? Insofar as you pick someone, anytime you pick an academic, and one who was not known for being a flamethrower,
Right.
as an academic, I don't know what Amy Coney Barrett's views are on a whole range of issues. That are important to a bunch of people on the right. I have a sense of what her views about abortion rights are, but I also know that she's someone who at least thinks carefully about precedent, and has not said, you just overrule whatever you want. So I think just stepping outside of, the progressive conservative, just as an observer of political behavior, I think there are a lot of risks. I mean, for a party that's devoted its Supreme Court strategy to no more suitors.
Right.
Not that she's going to be David Souter, but there are people you could pick who would be where I'd be very sure exactly what they would think on a whole range of issues. And her, I just don't know. Maybe people know things that I don't know, which is certainly possible.
So you don't have to react to this because I'm going to say something very controversial. So you don't have to react to it. But I suspect her very deep, and this is a known fact, her very deep-seated faith, which I'm not criticizing at all. But she is a woman of deep, deep, deep faith. I think that makes it less likely for her to change her mind over time on important issues. You don't have to react to that, but that's just my prediction. Souter, White, Blackmun, Stevens, I don't know how religious those four people were, but I'm guessing far less so than Alito and Scalia and Barrett. And that's I know that's very controversial, but I think that
Yeah, I mean, whether or not that's right. I mean, I wasn't really making a point about the likelihood that she might change her mind. It
Right.
was more that I don't know what her mind says to her right now.
Right.
Right. So, like, do I know what she thinks about like anti-commandeering doctrine? I can guess.
Right.
Right. But is it obvious that someone with her profile has a particular view on the non-delegation doctrine? I mean, again, I assume she does. I assume it's a conservative view or closer to where but I don't know that for sure.
That's fair. Completely
right.
fair.
And or criminal justice issues where she could, where her faith might lead her in different directions. Right.
Right.
So who knows?
So let's end with this. People know I wrote a book called Originalism is Faith. I think you're cited in that book more than any other academic. I could be wrong, but certainly your work on originalism really influenced that book and my personal journey through originalism. And you've written many articles, but one of them, and I want everybody who's listening to this who's interested in originalism to read this article. It's called The Selling of Originalism, and you wrote it a while back. I think it is one of the smartest pieces on a topic that has been overwritten by me and everybody else for the last 25 years. Is there a way to kind of quickly summarize your thesis in that piece? Maybe that's too hard a question to ask. I know you wrote it a long time ago, but it's a great piece.
Well, I appreciate that. It was my job talk piece. So as with everyone's job talk piece, I now cringe when I think about it. Right. So
you shouldn't, because it's great.
But I appreciate that. The basic thesis was a kind of two-part thesis. One, as I recall, I haven't read it in a while, but one being that part of the appeal of originalism is that it's easier to package. It makes more intuitive sense to people who haven't necessarily thought deeply about the problems that constitutional interpretation and construction present. And it I don't know if I said this exactly in that piece or in others, but it taps into certain deeper values that we have around the founding as well, that go beyond sort of law in a narrow sense, but tap into how we feel about America as a project. But there was a second piece of it, which is, when we think about interpretation, theories of interpretation, those are actually good features of the theory of interpretation. So that from a progressive perspective, at the time, progressives were big on popular constitutionalism.
Yes.
Right. And so if we think that law can evolve through social movements and through political movements adopting their own visions, that an interpretive method can be part of that. And so the way in which those who have supported originalism, starting with the mid 1970s through the early 1980s and the Reagan Justice Department and the Federalist Society, that those people were engaged in popular constitutionalism, and that there's nothing about an interpretive method that sort of takes it out of that space, and that so if liberals want to respond to originalism, it's not enough to simply say it's wrong for X, Y, and Z reasons, and now I'll publish that in the Columbia Law Review. You've got to get out and sell your method, and that's actually a sort of a totally legitimate, totally time-honored way of engaging in this project of constitutional evolution.
Right. I think one of the things you said in that article that I picked up on, and I then kind of went further on in my book, is that also originalism is different things to different people, and that's a really important point. to the Sean Hannitys and Fox News, correspondents who mouth the words, they have no idea what they're talking about, and it's a political label. But to academics who think deeply about these issues, and that's why I called it originalism as faith, as opposed to something else, they really believe it. I think I'm not suggesting bad faith on their part. And then to the justices, I think it depends. I think some act in bad faith on it, and some don't. And I think that your article touches on those things as well. That it's not just one thing. It's a lot of different things, and it's different things to different people. Is that fair? Is that a fair account?
Yeah, no, that's totally fair. It's a family of things, and
Yeah.
it's a family of things that are united by a certain set of values.
Yeah.
Right. They're not united by something jurisprudential, right? So I always think back to Justice Scalia in his very well-known book, A Matter of Interpretation, in which he said, the great debate in interpretation is between, old meaning and present meaning. It's not between intent and, intent and meaning.
Right.
And that's always struck me as an interesting, because you leave the United States, and everywhere you go, that's the main divide between intent in statutory interpretation. Intent versus meaning is a very significant difference.
Right.
Interpretively, it's a hugely important difference, but it's not a difference if it doesn't matter, right? If it's just a matter of you sort of aligning yourself with some basically conservative set of values, you're aligning yourself against progressive change. Then yeah, they are kind of. It doesn't really matter whether it's intent or meaning, because it's not a theory of jurisprudence, right? It's something else, and elsewhere I've called it a form of ethical argument, which is following Philip Bobbitt, who characterized a certain style of argument that taps into our character as a people, as a form of interpretation, and originalism really fits that, right? You're saying something about, are we a progressive people, or are we a people that are tied to a particular set of points in the past? And that aligns with standard progressive conservative debates in politics.
Right.
And so that connection has been drawn by the purveyors of originalism. And, tying your method to our values is something progressives could learn a lesson from.
Yes, that and selling progressivism better. I'm waiting someday for your piece, The Selling of Progressive Politics, or something like that.
Right.
But anyway, Jamal, thank you so much for doing this. This has been just wonderful. I'm going to hold it up again for the YouTube folks. This is a really good book. People should read it. How Rights Went Wrong, Why Our Obsession with Rights is Tearing America Apart. And I say it's a really good book, even though I think I want judges to do much less than you want them to do. But that's a reasonable disagreement and doesn't in any way take away from the enormous value of this book. So thank you so much for doing this.
Thank you, Eric. It's really been a pleasure.
Great.